November 25th, 2019 Mineland Reclamation Board meeting. With that, looking at the agenda, we're going to move along here pretty well today, I hope, with the assistance of our executive director, Tim Mott. But anyway, I would ask for a motion, if it's all clear, for approval of the August 2019 summary of the minutes.
I move that we approve the minutes.
Do I hear a second?
I second.
It's been moved and seconded. All those in favor signify by saying aye.
Aye.
All those opposed?
Aye.
Excuse me? Oh, thank you, Forrest. Anyway, hearing none, the motion's approved. We don't have any, to my knowledge, any continuances or withdrawals. So with that, I'll move into a short report, very short report from the executive director's office.
I was going to slow jam these, but okay. Good morning, members of the board. Director Brandon, Tim Mock, Deputy Director for the Department of Natural Resources. A couple of updates here in the last month. In regards to the Executive Director's office, we have some staffing going on. We are interviewing for the legislative liaison position right now, and we are reviewing applications for the policy analyst position. Expect to begin at those interviews shortly. And then we are going to revamp an assistant director position for, we're going to retitle that as for climate change and energy. And then some larger news here for the department at the beginning of the month. The Parks and Wildlife and the State Land Board released 80,000 acres into the public access program. August 21st, I think this was the day after our last MLRB meeting. I mentioned the governor was making a significant update. You all are familiar with that now, but that was the Wildlife Corridors Executive Order. And if you would like any detail on any of these items, please let me know. And then also later in the month, the governor announced the next state park, Fisher's Peak Crazy French near Trinidad. The water plan technical update was approved last week by the Colorado Water Conservation Board. This week, there is the C9 conference of the Basin Roundtables that is going on. Forest Service is launching a Rocky Mountain Restoration Initiative. It's a U.S. Forest Service-led initiative to address challenges and identify potential solutions that will lead to restoration of critical landscapes in the Rocky Mountains. Oil and Gas Commission is meeting today on some rulemakings, alternative location analysis, cumulative impacts, flow line mission change. There will also be an additional meeting tomorrow evening for the public comment from 4 to 7:30 at the Erie Community Center. And then in a bit of conservation news, the Parks and Wildlife is continuing to restore boreal toads to high elevation areas. Recently, 2,700 tadpoles were stocked in undisclosed ponds constructed by the Parks and Wildlife on the Rio Grande National Forest. This was the first time those ponds were stocked, and a check on September 1 showed that tadpoles had developed into toads and are now active. That concludes my report.
Any questions? See how much you can accomplish in a short period. I might add, I was fortunate enough to attend that function down at Crazy French Ranch on the New Mexico-Colorado border, and that's going to be that was a very nice, ceremony, but it's also going to be a real asset to Coloradans.
Yes, absolutely.
That'll be good, and the governor handled it very well, and so I was pleased to see. I actually was knew the French people when they bought that ranch in the 80s, so it's kind of fun to see that transition. Jenny, any good words from you?
Yes. Thank you, Mr. Chair. Jenny Brannon, Division Director. I've got just a few things. In the coal program, we will have a rulemaking coming before you in November. That is very unusual. We don't normally hear from coal, but the Office of Surface Mining has revised their rules, and therefore we must follow as a delegated program. The Office of Surface Mining started this rulemaking in 2011. Finally, we're there. And so now we can follow suit and revise ours accordingly. Our rules really pretty much match their rules just about word for word. And so if they change theirs, we change ours. So you'll hear that in November. And then as you know, I think I've mentioned this before, it's a big deal for the division. We are merging the coal and mineral programs with coal on a downtrend and minerals on an uptrend. We do, especially with respect to construction materials, we do need to leverage those resources. And so we are going to merge those into what will likely be called the Active Mines program. It's that's well, okay. And so we'll finalize that later. But by statute, we are actually the division of active and inactive mines. So it kind of makes sense. Anyway, to that end, we've got a couple of things. One, very exciting, is Jared Ebert was promoted to our senior. He was an EPS 3 here in the Denver office, and he's been promoted to the senior, and he will be over both coal and minerals. That's a first. And then all the other seniors will follow suit and be both coal and minerals as part of our merger. We're going to have a one-day retreat this Thursday to kind of hole up and talk about some of the details going forward and how this is all going to work. And so we are moving very definitely on this front to merge the programs. And then also, I think we've talked about this before. I think Chuck has talked about it. We did get a Court of Appeals decision in the Van 4 case, and it's in regards to temporary cessation. We're also going to need to clarify the rules on temporary cessation. In particular, what can operators do? Can they go in production and then go out of production, say after 4 years, then go in production again, and then the clock restarts on their 10-year time frame, or not? Or is it a cumulative thing? So they can go in production for 4 years, out for 3, but that's 3 years. Then they can go in production for 2 and out for 4. Now it's 7. Is it cumulative? Or is it actually 10 consecutive years? Van 4, the facts of that case did not warrant the court to make it to opine on that. So all we have really is context and perhaps reading between the lines of what they meant. But we need to sort of nail that down. And then also, when they say go in and out of production, what does production mean? We think it probably means more than just extraction, but okay, how much more? What is production? So those are the two things we're going to need to nail down. And unfortunately, our statute on that is really obtuse. And so it gives us very little guidance. So anyway, that will be coming before you at some point too, as we move through that morass. And then finally, we usually once or twice a year, we host international delegations, and this is very exciting, through 3 organizations. One is Rural Denver, one is El Pomar, and one is the Eisenhower School of National Defense in Washington, D.C. And they bring in delegations from around the world. We've hosted delegations from Mongolia, Colombia, Iran, others. And most recently, we hosted one from Africa. And normally it's usually from Afghanistan. Normally it's just usually one country. This time it was a coalition of countries, but all in Africa. And normally they want to hear about our regulatory programs because they want to know, how do we regulate? And they're usually almost always particularly interested in hard rock. What are our hard rock rules? What rules do we have and why do we have them? Because they are looking to extract their own resources. And this time they didn't, the African delegation, interesting, was singularly interested in water, and specifically was interested in a water drainage from abandoned mines. pre-law sites. And so it was strictly our inventory on our drainers. We have about 230 of them, and how we assess that and so forth. And Jeff Graves did an amazing job presenting to the African delegation. So we had a very nice time with them. And that, Mr. Chair, unless you have any questions or comments, or the board does, I concludes my report.
Questions or comments? Okay, thank you very much. With that, can you rearrange where do we want to start on the agenda?
Who's going to do the,
I know we're a little out of place with
Albert
the permission
Fryer.
of the board.
um,
We're going to be, which number is that?
6, right?
We're going to start with Albert Fry, formal public hearing, which is item number 6 on your agenda. All those,
Sorry, did we do consent?
oh, we didn't. While you guys are setting up, I'm going to ask the board to approve the consent agenda. If I could have a motion, you'll have to bear with me today. Is there a motion to approve the consent agenda?
So moved.
Is there a second?
Second.
Been moved and seconded. All those in favor signify by saying aye.
Aye.
Those opposed, same sign. Hearing none, the motion passes. Are we going to have people that are going to testify? What? None? Or not? We don't need to swear anybody?
No, if the board will recall,
Right.
last month we closed testimony.
Okay.
And so I think division might have a brief reminder of where we're at and then move into deliberation.
So Jared, you work with the division. Again, this is a formal public hearing for the AFS benefit on number M2001-038 regarding our Amendment 1 application. And basically, this is for the consideration of the board approval of the 112C amendment application. We'll receive public hearing. So we had an on-site meeting or on-site visit. We had an on-site visit at the end of last month, and from my understanding of the testimony, and so that's really where we are. And I guess it's only deliberations and the board's decision.
Any questions before we close? I guess the hearing's technically closed anyway, but any other, before we deliberate, any other questions or comments? If not, then I'll close the hearing again. And I wasn't able to attend, but I have to rely on your expertise and discussion regarding where we go from here. Those that attended, I guess.
Did you go? Yeah, you went and then Forrest was there as well. And Lauren, though she's not here. No, I appreciated the operator giving us a tour of the site. I thought it was really helpful. Pictures are helpful, but it's nice to see things in context and see the operations and see where several of the objectors lived and how close they were. There was nothing in that site visit, nothing in the hearing that we had that made me want to impose additional standards on the operator. I feel like that the application and everything associated with it met the standard of the rules and regulations. And for me, I think that we should approve over the objections.
Any other comments?
Tim Mock, I would agree with that summary of the site visit. I do appreciate, again, the operator opening up the facility, taking us around, as well as the members of the general public that also took the time to show up. But agree that it's fit within our regulatory standards for what the permit was asking.
Forrest, do you have any comment? I think you were in attendance.
I agree with what's been said. I didn't see anything that within our framework that didn't work as far as what the operation was attempting to do.
Okay, will there be a motion then?
I can make a motion. I move that we affirm staff recommendation and approve the amendment number 1 AM1 application for the AFS Bennett Pitt file number M 2001-38 over public objections.
Is there a second?
Second.
Second.
Moved and seconded. Any further discussion? If not, I'll call for the vote. All those in favor signify by saying aye.
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 All those opposed? Hearing none, motion passes. Okay, so then we go back to regular order, isn't that correct?
Right.
So we're doing item number 5, which is an enforcement hearing. Juliet Moore's Elk Creek Sand and Gravel LLC, Colorado. I could be wrong. Okay. Oh, do we need to swear people here? Is there going to be testimony?
From the division, yeah.
We can't trust them either, can we? You swear to tell the truth?
Yes.
Okay,
Eric Scott for the Division of Reclamation, Mining, and Safety here this morning. The reason for the hearing today is consideration of violation, civil penalty, cease and desist order, permit revocation, and finding the financial warranty subject to forfeiture for failure to submit the required 2019 annual reports, maps, and fees. The legal basis for the revocation and finding the financial warranty subject to forfeiture is included in your board packet. I'll skip reading over all those citations unless the board wishes me to. The required notification for this action was sent on August 16, 2019, providing the operator 30 days notice of this hearing. Proof of delivery of that notice is also included in your board packet. And staff recommendations at this point are for the board to affirm violation number MV 2019-022 for failing to submit the required annual report, maps, and fees for 2019 in accordance with CRS 34-32.5-116, parent 3, parent A, and parent B. Also to affirm the cease and desist order issued by the staff on August 16, 2019. Affirm the civil penalty of $323 issued by the staff on August 16. And order that permit number M 1978-208 be revoked. The division would also ask the board to find the financial warranty for permit number M 1978-208 in the amount of $10,400, subject to forfeiture pursuant to CRS 34-32.5-118, parent 1, parent B, and direct the staff to schedule a board hearing for forfeiture of the financial warranty and provide proper notice of the hearing to the operator and financial warrantor in accordance with the provisions of CRS 34-32.5-118, parent 2.
any questions? Any comment from the permittee of anybody here? Okay. Any questions from? Okay, I guess. Pardon me?
I was just going to point out to the board, as you may recall from our previous hearing in this, for this permit, that there is currently an outstanding corrective action also due for this site. We have not had any contact with the operator with respect to submittal or compliance with that corrective action at this time either. That would be technically due at the end of October.
Any discussion or comments or?
Mr. Chair, just to, I know there's a lot that comes before the board and it's hard to remember everything, but that, what Eric just referred to was the high wall. Yeah, okay, so now I'm seeing.
Okay, I guess we'll close the hearing and see if there's any discussion by the board, and if we need to have a motion to do what the board chooses.
Any discussion? Forrest?
No, I have nothing. Seems pretty straightforward.
Go ahead, Forrest. Okay,
I can make a motion.
that'd be good. Okay.
I move we affirm violation number MV 2019-022 for failing to submit the required annual reports, maps, and fees for 2019 in accordance with CRS 34-32.5-116, parent 3, parent A, and parent B. We affirm the cease and desist order issued by the staff on August 16th, 2019. Also, that we affirm the civil penalty of $323 that was issued by staff on August 16th, 2019. That we order the permit number M-1978-208 be revoked. And that the board also finds the financial warranty for permit number M-1978-208 in the amount of $10,400. Subject to forfeiture pursuant to CRS 34-32.5-118, parent 1, parent B, and directs the staff to schedule a board hearing for forfeiture of the financial warranty and provides proper notice of the hearing to the operator and financial warrantor in accordance with the provisions of CRS 34-32.5-118, parent 2.
It's been moved and seconded. Unless there's further discussion, I would ask for a vote on the motion. All those in favor of the motion signify by saying aye.
Aye.
All right.
Opposed? Same. Hearing none, the motion passes. Okay. All right. Now we're with number 7 on your agenda, today's agenda, enforcement hearing. William K. Havinger, Lazy H. Inc., Kinsburg, Colorado, Adams County. Oh, I'm sorry. You swear to tell the truth?
I do.
Thank you.
Jared Ebert again with the DRMS. This hearing is for the bootleg quarry, file number M2015-022, operated by Lazy H Incorporated. The reasons for the hearing today are for the consideration of violation, civil penalty, cease and desist order, permit revocation, and finding the financial warranty subject to forfeiture for failure to submit the 2018-2019 annual report, map, and fee for permit number M2015-022. And just to let the board know, this is a 111C operation. The permit area is 13.5 acres. The site is located in Adams County. It's about 5 miles east of Loch Bowie. We currently hold a financial warranty in the amount of $34,000 in the form of a corporate surety, and I do believe it is adequate to reclaim the site. To give the board an idea of the timeline, there's a chronology here on the presentation form. The anniversary date for this permit was June 15th of this year. And on June 16th, the division sent the operator an email notice that their annual report, map, and fee was overdue. They essentially have 60 days to get that in before we issue a violation. On August 14th, that 60-day period expired, and we did not receive the 2018-2019 annual report, map, and fee. On August 15th, we sent the operator a notice of violation, MV 2019-021, and we provided notice of today's hearing for the consideration of permit revocation and finding the financial warranties subject to forfeiture. On August 20th, we did receive a certified mail return receipt confirming that the operator did indeed receive our notice of violation. So the legal basis for permit revocation and forfeiture are outlined below there in your handout. But essentially, again, the operator was found to be in violation of CRS 34, 32.5, 116, 3A and B for failure to submit the annual report map B. And in accordance with 34, 32.5, 124, 6A, upon determination after a hearing that violation of a permit provision has occurred, the board may suspend, modify, or revoke such permit. Pursuant to CRS 34, 32.5, 118, 1B, a financial warranty is subject to forfeiture when the board determines that the operator is in default under a performance warranty and has failed to cure such default, although the operator has been given written notice and ample time to do so. Failure to file an annual report map and fee constitute a default under the operator's performance warranty, and they've been given ample time and notice to correct this. And to this date, I have not been able to make contact with them. We attempted via email, phone calls, and obviously they did receive our letter and no response. So what the staff recommends is for the board to affirm violation MV 2019-021 for failing to submit the required annual fee report and annual map for the 2018-2019 reporting year in accordance with CRS 34, 32.5, 116, 3A and B. Affirm the cease and desist order and the civil penalty of $504 that the staff issued on August 15th, and order that permit number M 2015-022 be revoked. Excuse me. And finally, we recommend the board find the financial warranty for permit number M 2015-022 in the amount of $34,000 subject to forfeiture pursuant to CRS 34, 32.5, 118 per 1B, and they should direct the staff to schedule a board hearing for forfeiture of the financial warranty to provide proper notice of the hearing to the operator and the financial warrantor in accordance with provisions of CRS 34, 32.5, 118 per 2.
Any questions or comments to the staff? Any responders to the permittee? Any people want to testify further?
I just had a quick clarification question. Sure. So it says that in 2017, you sent the notice that they're going to do the electronic filings. So this 2018, 2019, would this be the first time it was electronic, or was there?
I think they submitted last year's.
They did submit last year. That's what I was trying to clarify. So okay, yeah. This is out of.
They know the process.
They know the process. Yeah. Okay, thank you.
Okay. Any other discussion? Hearing none, I'll close the hearing. And unless there's other further discussion, I'll request a motion.
I'll make a motion. I move that we affirm violation number MV 2019-21 for failing to submit the required annual fee, annual report, and annual maps for 2018-19 in accordance with CRS 34, 32.5, 116, paren 3A and B. Affirm the cease and desist order issued by staff on August 15, 2019. Affirm the civil penalty of $504 issued by staff on August 15, 2019. Order that permit number M 2015-22 be revoked. Find that the financial warranty for permit number M 2015-22 in the amount of $34,000 be subject to forfeiture pursuant to CRS 34, 32.5, 118, paren 1, paren B. Direct staff to schedule a board hearing for forfeiture of the financial warranty, provide proper notice of the hearing to the operator and financial warrantor in accordance with the provisions of CRS 34, 32.5, 118, 2.
Is there a second?
Second.
Been moved and second. Any further discussion? Hearing none, I ask for a vote on the motion. All those in favor signify by saying aye.
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 Opposed, same sign. Hearing none, motion passes. Okay, I guess we're at item number 8, moving along on the agenda. Mike Bynum, Colorado Milling Company, LLC. Yeah, no, I was. All those that plan to testify, please stand to be sworn. You promise to tell the truth?
Yes, I do.
Okay, good. Go ahead.
Good morning. My name is Scott Schultz, attorney with the Colorado Attorney General's Office, representing the Division of Reclamation, Mining, and Safety. Colorado Milling Company has filed a motion, in this case, a motion for reconsideration. I have filed a response. My response is on page, let's see, 158 of your board packet. I do not believe that there's any need for any testimony on this motion. I believe this motion should be stricken as it did not meet the basic requirements of Rule 2.9.1 Parents 2. Nothing in Colorado Milling Company's motion meets the standards of the rules. The process and procedure are important in this matter. You don't get to continually relitigate the same issue. We had a hearing on this matter in June, and the specific portion of the rule that has not been met by Colorado Milling Company's motion is the portion that is including but not limited to new and relevant facts that were not known at the time of the hearing, and the explanation why such facts were not known at the time of the hearing. So nothing in their motion is new. It's simply a regurgitation of the same arguments that were made at the June hearing. Again, process and procedure do matter because you don't get to continually litigate the same issues in front of the board. So I think that the board should strike this motion, let the decision that was made at the June hearing stand. If the board does decide to, I guess, open up testimony and hear any of the relevant arguments, I would like to then have some time to go into those issues. But I believe on its face, the motion doesn't meet the basic requirements of the rule.
Any questions from the board to the staff's comments? I guess we have to make a decision if we want to take this further. Is that correct?
Yeah.
I don't know, what are the feelings of the board?
I think if we wanted to hear limited testimony with respect to whether there is new information whether there is new information that would satisfy the requirements of the rule, I think we can hear that very limited testimony, but keep it within that scope.
That
Yeah.
argument, right? How does the rest of the board feel?
Sounds good. Good recommendation.
I agree with that as well as Forrest.
We do. I want to appreciate what you're talking about too, but I guess the board would kind of like to hear from the permittee. I would like to know, I want to limit your time and I want to make sure we stay focused on what the staff talked about. How much time do you think you need?
Well, I think primarily, Vice Chair Singletary, this is a relatively technical motion on a limited area and, pardon me.
Well, to battle the attorneys here.
We just want to make sure you stay
Yes.
focused on the.
Very
guidelines
focused.
We're talking about here.
Vice Chair Singletary, I don't know if the board knows, but since the hearing we had.
Can you introduce yourself, sir?
Oh, pardon me. I'm usually so easy to hear. Since our hearing back in June 26th.
I'm sorry. Can you just introduce yourself for the record?
I'm John Henderson, Colorado 9013, appearing for Colorado Milling. I guess I've become such a frequent visitor that I sometimes assume people know who I am. At any rate, since the hearing on June the 26th, the AM1 application continued to be processed. Just before that June hearing, Colorado Milling had filed a response, a fourth adequacy response to division. The board asked that processing continued. The division issued a further fifth adequacy letter to which Colorado Milling responded, and we were notified of the approval of Amendment AM1. As a matter of fact, we got the notification a couple weeks ago, and the formal letter was received yesterday, which initiates any 60-day appeal period. After the board meeting originally, I received a copy of the decision of the board, which was initially addressed, interestingly, to Robinson and Sons. That was on August the 6th. And then I think the board remailed the decision on August 13th addressed to Mike Bynum. In both instances, there is a recitation in the final order and conclusions of law here at section 28. The board may impose a civil penalty of not less than $50 per day nor more than $200 per day for each day during which violation occurs. Here, the board may impose a civil penalty of $50 to $200. In the final order, on the final page, the board imposes a civil penalty of $50 per day for 36 days of violation, for a total civil penalty of $7,200. 50 times 36 is actually $1,800.
I could just address that. That was my mistake in drafting. I think the record's clear as to what the board ordered that day. And quite frankly, council and I engaged in back and forth. He requested a review of the draft order, reviewed it, brought the issue of he didn't think that the civil penalty was assessed. I directed him to a recording of the hearing. He didn't raise the math issue at the time. Happy to fix that, but the order imposes the penalty that the board found. So,
Go ahead.
In continuing, there are really two motions before the board. One is my motion for reconsideration of the civil penalty. In part, the order itself as issued contains a mistaken calculation. It would have to be corrected. Under the circumstances, and those are outlined in my motion, which are very short, this has nothing to do really with everything that's gone under the bridge through the approval of AM1 amendment. However, it is clear that on May the 21st and on two occasions thereafter, the division asked us to submit a request to the board for extension to meet its adequacy response. Specifically, we were informed by division, and I'm not pointing a finger at division. This was highly logical because they had just on the deadline, May 21st, issued their next adequacy letter. Our response was going to need to be extensive, and division knew this. And so they informed us in writing that if we filed a request for an extension prior to June the 6th, that we would be taken off the enforcement agenda. And what would be before the board would simply be our request for extension. So on June the 5th, we did file with them a request for an extension of 30 days. And thereon things kind of fell apart. And rather than getting the extension, they denied the permit on June 12th, permit amendment AM1. And we ended up back on the enforcement agenda. So under the circumstances, at the time the board is having to revise the order to reflect the correct assessment of penalty, we have raised a question as to whether the penalty assessed was appropriate given the facts that were in the record. And I'm not sure the board had a full understanding that division had invited us with logical reason to file for an extension and indicated they would support it because they knew it was impossible to respond overnight to their latest adequacy letter. That's all been solved. The AM1 has been approved. The board is going to have to amend that order anyway. And we're asking for consideration as to whether a penalty is appropriate under the circumstances, since we did exactly what division asked. And after they denied AM1 on June the 12th, we had no way of further complying because they couldn't approve AM1. So we're asking either for a suspension of the civil penalty, for its limitation to at most a technical violation from May 21st to June 12th, assessed at $50 a day, because that seems more appropriate, because you always have to define what is the conduct being punished? What is the action of the operator that's being punished? And we were invited to file for the extension, indicated staff would support it. We timely filed within the period they requested, and now we're being fined for a period of, I believe, 36 days. So I think that's inappropriate, and besides, the order does need to be corrected anyway in both the forms it was issued. Does the board have any questions for me? I think it's primarily a technical issue.
Board. I guess not.
Thank you, sir. Thank you, board.
This is Scott Schultz again with the Colorado Attorney General's Office, representing the division in this matter. I again stand on my motion that nothing in their motion is new. These are the same issues and arguments that were brought before you on June 20 in June. The issue of the math error is nowhere in any of their motions. So be that as it is, I don't. The petitioner has not met their burden to have their motion for reconsideration considered. So I think it should be stricken. So I would like a ruling on that from the board before I go into kind of a deeper dive into what the penalty issues are and kind of the history of this case. Just really to save the board some time, and to, again, procedure and process is important, because you don't get multiple bites at the apple to relitigate the same issues when you don't get the result you want initially at the board hearing. Nothing is new that they brought to you today.
Any questions? So if he wants a decision from us on his motion, would we close that part of the hearing and then vote on that and then reopen again, I guess, if you need to go further?
Yeah, so just kind of procedurally, what we've got here is a motion to strike, the motion to reconsider. So you hit the nail on the head. I think closing, deliberating, having a decision on the motion to strike, and then depending on how that turns out, if it's necessary to move back to the motion for reconsideration, depending on the outcome of deliberation on the motion to strike.
Yeah, I would close the hearing then at this point and go into deliberation with the board to find out your wishes.
I just said I agree with the staff's recommendation.
I think the division's motion is well taken. I did not see anything in the motions from the operator that really added new information that we didn't discuss or know at the time of the hearing. And honestly, I would feel uncomfortable. We would have to almost reopen the entire hearing again to hear everything all over again. We made that decision at that time on all of the information we had before us, and I haven't heard anything new or different.
Forrest, do you have any comment?
Well, I guess I've been confused about this issue all along. As you recall, I voted against the imposition of a penalty, and I continue to feel that way. I'm confused about what went down as far as timing of the different motions. I guess my bottom line is I felt like they were working toward a resolution, and I still don't understand why the division brought the hammer down. the way they did. And so I guess I continue to feel that way, and I would, I guess, be sympathetic to a reduction in the penalty.
Now, do you have any comments?
No, nothing that hasn't already been said.
Okay, is there a motion?
I move that we strike Colorado Milling's motion for failure to meet the requirements of Rule 2.9.1, Rent 2.
Is there a second?
I'll second.
It's been moved and seconded. All those in favor signify by saying aye.
Aye.
All those opposed, same sign.
Nay.
Okay, we have a nay. Those opposed, the motion carries, so I say we supported the staff on the motion. So we don't need to reopen, right?
Correct.
Okay. So I want to make sure we're initially right. Okay. Can we move on? Settle on, pretty good. Agenda item number 9, Ross Peterson, Lamar, Colorado, Bent County.
Hello, this is Amy Ashburger with the division. Turning on the microphone. Okay, it's on now. Testing. This is Amy Ashburger with the division. This is an enforcement hearing for consideration of violation, civil penalty, cease and desist order, permit revocation, and finding the financial warranty subject to forfeiture for failure to submit the required 2019 annual report map and fee. This is for permit number M 1996-013, the Hasty Pit. The permittee is Carter Inc. This is a sand and gravel pit located in Bent County, and it's a 112C operation permitted for 157 acres. And we currently have a $75,000 bond on this operation. So on June 6th, that was the anniversary date for the annual report, and the operator did not submit the report. After the 60-day period, we sent out the notice of violation on August 12th for violation number MV 2019-013. And I did go inspect the site on September 11th just to assess site conditions and see if the bond was adequate. And I found that the current bond is about $33,000 short.
I need to stop you for a minute.
Okay.
I need to swear you in.
Oh,
I know you.
true. I got sworn for the Gold Hill, but not for this one.
Okay.
Okay.
Promise to tell the truth.
Yes.
Okay. Excuse me.
Sorry.
So I promise it was $33,000 deficit on the bond.
I feel better about that. Yeah.
And so the report didn't get submitted. The operator was noticed. And I will just go ahead and note for the record, for what it's worth, did have some communications with the operator. And you may already be aware, you've seen other Carter sites come before you for the same thing. This is the last of those. And Carter Inc. has been dissolved. And, no more work is to be done on the site. They did get a lot of reclamation work done out there, a lot of the earthwork. So we're basically down to seeding and some minor erosion and weed control. But that's the situation. So the operator was found to be in violation pursuant to CRS 34-32.5, 116(3)(a) and B. And the rest of the legal basis there for revocation and for finding the financial warranty subject to forfeiture is outlined for you. Won't go through that unless you want me to. The division did mail the operator a notice of the violation and of notice of this board hearing. And they had a minimum 30-day notice. They decided not to attend. And Staff recommendations at this point are for the board to affirm violation number MV 2019-013, which was issued by staff on August 12th, 2019 for failing to submit the required 2019 annual report map and fee in accordance with CRS 34-32.5-116 3A and B. Staff also asked that the board affirm the cease and desist order that was issued on August 12th, to affirm the civil penalty of $791 that was issued by staff on August 12th, and to revoke permit number M 1996-013 pursuant to CRS 34-32.5-124, parent 6, parent 8. And staff also asked that the board find the financial warranty for permit number M 1996-013 in the amount of $75,000 subject to forfeiture, and direct staff to schedule a board hearing for forfeiture of the financial warranty. And we will provide proper notice of this hearing to the operator and the financial warranty, or warrantor, I'm sorry. And that completes my presentation. Does the board have any questions for me?
Any questions? Looks like you did a very good job. No questions. Anybody from the public or the permittee want have any comments? Sounds like no one's here. So
Don't believe they intended to
Right.
come today.
okay, with that, I'll close the hearing and open up for discussion and deliberation by the board. That can also include a motion.
I move that we affirm violation number MV 2019-13 issued by staff on August 12, 2019 for failing to submit the required 2019 annual report, map, and fee in accordance with CRS 34-32.5-116 3A and B. Affirm the cease and desist order issued by staff on August 12, 2019. Affirm the civil penalty of $791 issued by staff on August 12, 2019. Revoke permit number M 1996-13 pursuant to CRS 34-32.5-124 6A. Find the financial warranty for permit number M 1996-13 in the amount of $75,000 subject to forfeiture pursuant to CRS 34-32.5-118 1B, and direct staff to schedule a board hearing for forfeiture of the financial warranty and provide proper notice of the hearing to the operator and financial warrantor in accordance with the provisions of CRS 34-32.5-118-2.
Second.
Been moving and seconded. Any further discussion? Hearing none, I would ask for a vote. All those in favor signify by saying aye.
Aye.
Those
Aye.
opposed, same sign. Hearing none, motion passes.
Thank you.
You think? Well, got stuff to do here. Take a short break. Why don't we take about a 10-minute break and then we'll finish off the agenda. Chair.
John, hold on.
We good? Are you here regarding agenda item number 10?
So is that the pipe quarry?
It is.
Yes, that's what I'm here for, yes.
Okay, do we need anybody sworn on this?
Not sure, we've got an attorney in background, I'm not sure he needs to be sworn in. I'm not sure they're going to say anything. It's just a presentation of a stipulated agreement, so.
Okay,
Fairly simple.
okay, go ahead.
Jeff Fugate here on behalf of the division. Again, this is just a presentation of a stipulated agreement in the Pikeview Quarry matter. If you recall, for the last few months, this matter has been showing up on the board agenda just as status updates. So this is I believe the final status update, or at least kind of reserved spot on the board's agenda as the division staff is reviewing an amendment application to revise the reclamation plan for this site. Just as a kind of a refresher, and I believe you all have the hard copies of the agreement in front of you. I'll just quickly go through some of the relevant facts. This matter was before the board on a increase in the bond. The division conducted a bond calculation, calculated the bond at approximately $21.9 million. An appeal or objection to that calculation was filed by the operator. So it went before the board, I believe in July, for consideration of that appeal. So that bond or that board hearing where there was an agreement reached between the operator and the division that the operator would post a $15 million bond, submit an amendment application to revise the reclamation plan with the intent that the approved reclamation plan would either align itself with the $15 million bond or at the very or lead to some additional recalculation of the bond to land on the proper amount based on that approved plan. One of the concerns of the division at that time was in the event that the amendment application is not approved by the board or the division, where does that leave staff with what they believe is still a deficient bond amount of approximately $6.9 million? That's what this agreement is doing, is trying to essentially hold a place for consideration of that bond increase, again, in the event the amendment application is not approved. So what this outlines, again, page 2 and 3 of this agreement, just simply an agreement that the operator, again, in the event that the amendment application is either denied or withdrawn, operator will submit a $6.9 million bond to the division within 60 days of that effective date of denial or withdraw. Or if the operator seeks to dispute that amount, they need to file a notice with the division of the board within 15 days of the effective date of denial or withdrawal. And the matter will be set for hearing at the next regularly scheduled meeting. And the final agreement is, again, in the event of an approval of that amendment application, there's a commitment to do a bond recalculation, putting in all of the necessary amendments to that calculation based on approved reclamation plan, extent of work that is conducted on site between now and the approval date of that plan. So, as I said, this agreement is really just to kind of create a placeholder so that we can pick up where we are leaving off with the bond calculation in the event the amendment is not approved. If you have any questions on this agreement itself, I can answer those questions. To kind of just close the loop on the current status, again, the operator did submit a timely amendment application. They also submitted the $15 million bond amount, and the application is kind of in the early stages of division review and moving forward on that. Available for any questions. Again, Scott Anderson is here on behalf of the operator if you have questions for him as well.
I'm sorry. When is the division's decision date?
I'm not sure if we have a decision date. Michael, do you have a decision date on that?
Generally is fine.
End of December
Okay.
is our decision date. We anticipate that probably.
Okay, thanks.
So just for clarification, the timeline then would be before the end of the year. Is that what you're thinking? I mean, kind of give me a timeline on what's happening here.
Sure.
I know I explained it, but
Yep, and it's all subject to whether or not objections are received. That will add some time. It sounds like the division will find some aspect of this application complex, which will add up to 90 days to the review time period. So it could take a variety of courses, but likely if it is extended, does receive objections, we're looking at February, March time period at the earliest that can come before the board for consideration. On the short side, if there are no objections, and if there is an extension but it's not long, then you may be looking at kind of a January, February time period. If there's no objections at all, there's no requirement that it'll come before the board. Decision will be made by staff.
So objections need to come from not just the staff, but the public. Is that right? And how are they notified and what's going to, how, I mean, I'm sure you explained all that, but tell me.
Sure. Again, this is it's an amendment to a 112 application. So it's going to follow that process. Notice of this application is published in the newspaper for 4 consecutive weeks. There's a 20-day comment period after the last day of the publication date. So comments can be received from the date that it's published initially, the first time, and then 20 days after the last publication. So it's approximately that'd be a 60-day comment period. Comments are received by the division. Then that triggers pre-hearing conference process, and then a formal hearing. While all of the comment period is running, the division is conducting its own internal adequacy review process. So they're raising and getting technical responses to their own questions kind of during the course of review.
So really all this amendment is concerning, we have 15 million, whatever, plus or minus. So this really concerns us 6 million something additional that we right now feel like we need to make sure something goes wrong, that'll take care of it. Is that correct?
That's correct. That's what this agreement is trying to do is, again, in the event that the amendment is not approved or it's withdrawn, we want to make sure that this $6.9 million deficiency as found by the division isn't kind of lost in the shuffle of all this. We want to make sure that the division has to have to start over, renotice the bond increase, trigger that process. We want to essentially just have a process where we jump right back into either an agreed upon amount that's paid or a fast track to a hearing before the board for consideration of whether that amount is proper or not.
So, but I thought, what we've been working toward was Continental was going to provide us information that they could do it for less than the 20-some million. That they haven't done that. So this gives them some more time to prove that, or we're going to show that I'm a little.
Sure. I think all of that will be part of the amendment review process. The reclamation plan that they proposed through this amendment may reduce the bond.
Right.
May reduce it even more than
they were going to show us why we needed to reduce that bond, and
right.
That hasn't happened yet.
That has not happened yet. At least it is commenced through the amendment process, but that won't be completed until, again, there's some final determinations on that reclamation plan, which will include an eventual recalculation of the bond to see if the amounts that's currently held is sufficient to cover the liability under the new plan, or if there still is some amount of deficiency. So it's all of that will be wrapped into this amendment review process.
Okay.
Mr. Chair.
Yes, sir.
Russ Means with the division. Just a little clarification and stuff. When we did the bond calculation, it's based on the current reclamation plan. And the operator has provided, they did provide us with some information and stuff that showed that they could kind of do some different tasks, some different ways that would probably reduce that amount, but that's not part of the current plan. So that's why we're doing the amendment. The amendment's going to try to address some of the different aspects and stuff that they're looking at in their reclamation plan to try to get that number down to something that we can both agree on. But again, the initial plan and stuff, that's what the current bond is based on. We're hoping at that through the amendment process and stuff to review some things and maybe close that gap on that $6.1 million. So.
Okay. Is there any? Do you swear to tell the truth? Can you step forward here and look?
Good morning, Scott Anderson from Hogan Lovells on behalf of Continental. I just want to give you a sense of the numbers so you understand how this is stacking up. So under the existing reclamation plan, that's where the bond would be was calculated 21, almost 22 million to implement the existing plan. When we were before we said we thought we might be able to do it for about 12. We agreed to put 15 up to give you a little bit of cushion, so you were comfortable that as we're pushing toward this new and improved plan, there was more than enough bond in place to actually, do the work that were likely to be done. We have submitted an amendment. The amendment comes in round numbers around 9 million. Understand that's subject to approval and review, but that's when we do the number on the new and improved plan, which again, less dirt movement, safer approach to mining is, the rationale to it. We think that number is going to be well less than the 15 million that's in place right now. So what we've stipulated to is that we'll keep the 15 million in place throughout the process. We'll review the plan. We'll get the plan approved, hopefully. We'll recalculate the bond at that number to whatever it is for that plan, which we think is going to be well less than the 15 million. But the stipulation says is that if we're not successful in getting the new plan approved, then we go back to the 21 million and we talk about that. We may very well agree that that's the number, existing plan, but we have the right to contest that number. So we're kind of going back to where we were before the last stipulation. So that's how all the numbers fit together. But the important thing for the board to understand is that the 15 million is well above what the likely actual reclamation is going to be once we work through the amendment.
So you say. Well, then that's fine. I'm just saying, we just have to watch out for Colorado, that's all. So.
Understood.
Is there any more questions? Or thank you for that, by the way, thank you for that clarification, both of you. This is kind of a big deal. Okay, thank you. Any other questions, or you have the experts here?
Just a clarification, you're asking the board to approve the joint stipulation. That's what your
Correct.
motion would be. Okay.
Okay. Yes, sir. Yes, ma'am.
If I could just add, this is really up to the operator in terms of what kind of permit amendment they bring before us, and then what truly, the financial liability is. We're not advocating one way or another. It's really up to them, and we're just going to go by the science and the numbers.
You're just waiting to see what they provide us.
Exactly.
Okay. Any other discussion? But really, this wasn't a hearing, I suppose. Do I need to close the hearing?
Might as well. That testimony.
Oh, is there any other further testimony from? Oh, that's all right. Folks out there? Okay, thanks very much. I appreciate the clarification. With that, I'll close the hearing. Any discussion? I would ask for a motion.
I move that we approve the joint stipulation.
Is there a second?
Second.
I need your help. Okay, the motion's been made and seconded. All those in favor signify by saying aye.
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 Those opposed, hearing none, the motion passes. So the amendments. Stipulation. What else do we have? Is there any public comment, by the way? Was there? No, okay. Any other public comment? Certainly welcome to get up and address us. I guess that's it then. Do we need executive session for any reason? Any other discussion? No pearls of wisdom? Okay, with that, we stand adjourned, and thank you very much.